Hi, I'm Kenneth Marcus from the U.S. Department of Education's Office for Civil Rights. This video is intended as an overview of how to file a sex discrimination report or formal complaint with a K-12 school or a post-secondary institution such as a college or university. The Office for Civil Rights, or OCR, enforces Title IX of the Education Amendments of 1972. That law prohibits discrimination on the basis of sex by K-12 schools and post-secondary institutions receiving federal funds in the United States, including ones whose students use federal funds to pay tuition. We'll refer to these different schools under OCR's jurisdiction as just schools for the sake of simplicity. We will also note the specific instances where the rule has different requirements for K-12 schools versus post-secondary schools. Under Title IX, once a school has notice of sexual harassment or an allegation of sexual harassment, it must respond appropriately. The Department's new Title IX regulations, which become effective on August 14, 2020, set out clear standards that inform students, schools, and others of their rights and obligations under the law, including reporting sexual harassment, initiating a formal complaint, and the due process procedures that provide prompt and equitable resolution of complaints. Under Title IX, sexual harassment in education programs and activities is defined in several ways. One is unwelcome conduct that a reasonable person would consider to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity. Another is quid pro quo harassment, meaning a school's employees' conditioning of an aid, benefit, or service on a student's participation in unwelcome sexual conduct. A third is sexual assault, dating violence, domestic violence, or stalking, which is not only subject to a school's disciplinary procedures, but also to state criminal laws involving local law enforcement authorities. Before we discuss reporting sexual harassment under Title IX, it is important to clarify the difference between that process and other types of reporting. Reporting under Title IX is distinct and separate from reporting sexual assaults and other crimes to law enforcement. Additionally, a school's obligations under Title IX are separate and distinct from its obligations under another federal law known as the Clery Act.
What should you do if you are a victim of sexual harassment? Reporting harassment to your school's Title IX coordinator is always sufficient to put a school on notice of an allegation of sexual harassment. And all schools that receive federal education funding must have a designated Title IX coordinator and provide that person's contact information, where they can be reached or leave a message 24 hours a day, 7 days a week. The Title IX coordinator of a K-12 school, college, or university must be readily available and accessible. All schools must prominently display the name, title, and contact information of the Title IX coordinator or coordinators if there is more than one on its website. In addition, the student handbook or catalog must include the name and contact information of the Title IX coordinator. Schools must also provide notification to students, applicants, parents, legal guardians, school employees, and all unions or professional organizations connected to the school of the Title IX coordinator's contact information. However, reporting sexual harassment to the Title IX coordinator is not the only way to put a school on notice. In a post-secondary school, individuals can also report sexual harassment, which includes sexual assault and sexual violence, to anyone within the school who has authority to institute corrective measures on behalf of the school. Schools may choose to designate some employees as confidential resources to whom a student or employee at a post-secondary school might disclose and discuss sexual harassment without automatically triggering a report by the employee to the Title IX coordinator. At the K-12 level, the scope of who may be told is even bigger. Anyone who wants to report an incident of sexual harassment may tell any school employee, regardless of that employee's job description. This means that in addition to teachers, administrators, and security personnel, a student or other person may report sexual harassment to, for example, school bus drivers, cafeteria workers, maintenance workers, or anyone else who is either employed by the school or under contract to the school. In fact, employees may be the ones reporting if they are witnesses to harassment. Even if sexual harassment is not reported to a school employee, but that school employee has notice of allegations of sexual harassment in an education program or activity, then the school must respond. It is important to understand the difference between reporting sexual harassment and filing a formal complaint. In a nutshell, anyone may report sexual harassment, and reporting sexual harassment requires the school to offer supportive measures to the complainant and inform them of the process for filing a formal complaint. Filing a formal complaint requires the school to follow a grievance process to determine whether the respondent is responsible for the alleged sexual harassment. It is important to know that reporting sexual harassment does not trigger the formal complaint process. The filing of a formal complaint is separate. When a school learns that someone is said to be the victim of sexual harassment, it must promptly contact the person to discuss supportive measures, consider that person's wishes with respect to supportive measures, and offer supportive measures. The school also must inform the complainant that supportive measures are available with or without the filing of a formal complaint, and explain to the complainant the process of filing a formal complaint. Supportive measures are non-disciplinary, non-punitive, individualized services offered without fee or charge to the complainant or the respondent. They are designed to restore or preserve equal access to the school's education program or activity without unreasonably burdening the other party. These services include measures designed to protect the safety of all parties or the school's educational environment, or deter sexual harassment. Schools must keep supportive measures provided to the parties confidential to the extent possible. Supportive measures may include, but are not limited to, counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort services, mutual restrictions on contact between the parties, changes in work or housing locations, leaves of absence, increased security, and monitoring of certain areas of the campus, and other similar measures.
A formal written complaint is a document filed by a complainant or a person who has a legal right to file on their behalf, like a parent, or signed by the Title IX coordinator alleging sexual harassment against a respondent, and requesting that the school investigate the allegation of sexual harassment. The complaint is any document or electronic submission, such as an email, that contains the complainant's physical or digital signature, or otherwise indicates that the complainant is the person filing the formal complaint. Upon receipt of a formal complaint, a school must initiate its grievance process and also offer ongoing supportive measures throughout the grievance process. The grievance process provides due process and fundamentally fair procedures to adjudicate the allegations of sexual harassment. For example, the grievance process requires the school to provide both parties with notice of the allegations of sexual harassment that the school intends to investigate, an investigation that allows both parties an equal opportunity to inspect and review the evidence, a written determination regarding responsibility, and an opportunity to appeal any determination regarding responsibility. A live hearing is required for post-secondary schools. A live hearing is not required for K-12 schools. Filing a formal complaint, either by the alleged victim or their legal representative or the Title IX coordinator, is the only way that disciplinary sanctions may be imposed on a respondent under the Title IX rule. However, in circumstances where a school determines that there is an immediate threat to the physical health or safety of a student or other individual arising from the allegations of sexual harassment, a school may remove a respondent from the education program or activity on an emergency basis. The school must provide the respondent with notice and an opportunity to challenge the decision immediately following the removal. Finally, it is important to note how law enforcement activity affects Title IX. The existence of law enforcement activity, such as a police report or investigation, criminal charges, or court proceeding, does not relieve a school of its obligations under Title IX, which include concluding any grievance process within a reasonably prompt timeframe. A school, however, may temporarily delay its grievance process or the timeline for certain parts of the grievance process for good cause, which may include concurrent law enforcement activity, so long as the school provides written notice to the parties and the reasons for the action.
This short video has touched briefly on many topics. To learn more about these topics and the entirety of the department's new regulations, please visit www.ed.gov/OCR. If you have questions regarding the department's new regulations, please send them via email to t9questions@ed.gov. Anyone who believes that a school has violated a federal civil rights law enforced by OCR can file a complaint online at ocrcas.ed.gov. Links to these sites and other information are posted in the video description.